All rise. Juvenile Court of National Davidson County is now in session. The Honorable Sheila Calloway presiding. You may be seated and come to order, please.
We did have everybody.
That always happens. Mac, you all right back there? You want to use? Okay. Good thought we got it. Okay. All right. We are here on the matter of Abigail Geiger. We are here on petition number 239264, which is an emergency petition to adjudicate dependency and neglect, a request for court order service, and ex parte restraining order. This petition was filed on what it looks like April the 30th.
Is that
May.
the department's petition?
That's
May.
the department's petition that I have.
It'll be April 2018.
I'm sorry. April, you said April 8th?
It will be May, I think May
No,
1st.
April 30th.
Okay, yeah.
Okay. April 30th of 2018, by the Department of Children's Services. We have other petitions that were listed on the decree, but from my review of the file and the notes, there were final orders on the AC number as well as the other petition number. There was a disposition that was done, and I think the department's petition was filed based on the behaviors after that disposition. I'm sure I'm wrong because this thing goes on and on and on. However, that is the only thing that I see that is still pending as to adjudication for now.
As to adjudication, correct, Your Honor. Dispositionally, your order from April 2018 that was set down some perimeters. As a result, the department's petition came in place to suspend that was happening on your order. So yes, as to adjudication, it is only the Department of Children's Services petition.
Okay. We have with us today Ms. Charlena Mack, who is the guardian ad litem for the child. We have Ms. Lydia Hubble, who is the mother for the child. We have Mr. Sinan Gadir, who is the father for the child. He is represented by Ms. Susan Mader. We have Ms. Christine Carlton, who is the attorney for Department of Children's Services. We have Ms. Adrienne Stewart, who is the DCS supervisor. We also have with us from DCS. Say the name.
Dontavia Rucker. She's the brand new case manager.
Okay. All right, and then we have from school.
Elizabeth gets from Gallo.
From Gal. Okay, I remember her from the last time she was here. Elizabeth. Spell the last name again.
It's Goetz.
Okay,
Assistant principal.
from Gal. All right. Let me get all those who are going to testify in this matter. Please stand and raise your right hand.
Wait, Your Honor, I had a
Well,
question.
let me get you under oath first. Is Ms. Rucker going to testify? Or?
I don't think that she's
Okay.
going to, she's only attended one CFTN,
Okay.
so there may be one little thing.
Well, yes, because she heard some things at the
Yeah.
CFTS.
All right, go ahead and stand
She
up for
will
me.
testify to. Yeah.
Do you swear or affirm statement what you're about to give to be the truth, whole truth, and nothing but the truth, so help you God?
All right, and is the rule requested? Is a sequestration of witnesses rule requested? Ms. Hubble?
No.
No? Ms. Mack?
None, Your Honor.
Okay. All right, everybody can remain in the courtroom. All right, and then for a preliminary issue, we were previously here on Ms. Davenport's motion to withdraw from representing Ms. Hubble, and that was granted. And Ms. Hubble at that time said that she would be representing herself, and so we are here. Although this is a neglect and dependency matter, the mother is entitled to attorney. However, she has decided to allow her previous attorney withdraw.
But Your Honor, I objected. I objected to her withdrawing.
Okay, but I think based on some of the information, the court did find that it was appropriate for her to withdraw pursuant to the Tennessee rules of Supreme Court that Ms. Davenport cited Rule 8, 1.6 were basis of allowing her to withdraw. And so the mother is representing yourself today. Is that correct?
Yes, it is.
Okay. All right.
But I do have a question. I didn't understand what you said. Now, when we were here in January, you set this motion to remove restrictions from mothers' parenting rights for today. Did I just hear you say that you are not going to hear this after all, after we've waited all these weeks to hear this?
No, what I did say was the only petition that is still pending right now is the petition number 239264, which is the petition that is the emergency. We're going to hear the adjudication on that. And then if there are other motions that are still pending after that, then we will hear that as well.
So the motion for my Rule 11, or my motion for Rule sanctions under Rule 11 for the misrepresentations that were made in DCS's allegations against me, that's going to be heard today. And my motion to remove restrictions for my parenting rights, that's going to be heard today as well?
We'll see what we can get to.
Okay,
We got
so you
today and all
did
day
not
Wednesday.
say, you did not say that you weren't going to hear this. You just said that it's
The only thing that's for, the only petition that's still pending for adjudication right now is the
DCS
department
petition.
petition, and
Okay.
we'll start with that.
And I was unclear what all was being heard too, coming late to this party here, because I know that our petition was set on a day that had already been scheduled for hearing of something, and I'm not sure what. Was that the petition that Ms. Hubble withdrew?
Well, she had filed a motion to alter or amend or set aside the order, and she's already heard it. That was something that was previously set, and I believe she already heard that.
Okay.
And there was something that we did have set that
And then she
Ms. Hubble
filed a
withdrew.
petition,
that-
but she not do that.
Yeah, she did not see her
Okay.
petition. So the only petition that's still open for adjudication is the department.
Also, according to the local rules of juvenile court, you told me that I needed to submit a certificate of readiness, and I just need some clarification on the rules and who they apply to. This Rule 11, Certificate of Readiness Witness and Exhibit lists, it says, in all cases set for adjudication and or disposition except for delinquency cases, and this is not a delinquency case, a certificate of readiness containing the following shall be filed with the court and served upon all parties no later than 10 days prior to the scheduled hearing. And it says, A, witness list, including the names, addresses, and phone, if known, of all witnesses other than impeachment or rebuttal witnesses. Any witnesses not so listed shall not testify other than impeachment or rebuttal witnesses. B, an exhibit list, copies of exhibits to be proffered at trial other than impeachment or rebuttal exhibits. Exhibits which are not easily capable of photocopy reproduction shall be identified and made available for inspection by opposing counsel. Failure, and then it says, failure to comply with this rule could result in sanctions to the attorneys and offending parties' witnesses not being able to testify. And I received an email. I received an email from Christine Carlton saying that she was not required to comply with Rule 11. And I asked her to cite the legal authority she had for that, and she didn't answer my email. So I would move for sanctions to the attorneys and offending parties' witnesses not being able to testify under Rule 11 of the local rules of the juvenile court for the metropolitan government of Nashville and Davidson County.
All right, Ms. Carlton, your response.
I have no witnesses other than the parties, Your Honor. I have no exhibits except for impeachment or rebuttal. I don't think anybody else does either.
Same with
All right.
I
So-
don't plan on calling any witnesses.
All right, Ms.
So they're not going to be allowed to call their own witnesses. They're only going to be able to cross-examine my witnesses. Is that correct?
Now, what they're stating is that they did not do, you did not submit a certificate of readiness, is that correct?
Correct.
And the reason is because you had no intent to call anyone except for the parties.
Right.
There's no exception in this rule, Your Honor.
The parties are always assumed to be allowed to testify. That's it. Like, we're not calling, you
Your
are not
Honor?
secondary witnesses.
This comes down to, are the rules equally applied to all parties? That's what this is what this boils down to. What does the law say? What do the rules say? If you're going to make an exception to DCS that you were not willing to make for me, then because you specifically told me to do a certificate of readiness and not them. So if you're going to be inconsistently applying rules, I would move that you recuse yourself on the basis of bias.
And I would argue it's not an exception, it's common practice in this court. And we've done it for years that way, that's why everybody agrees. And the reason why she had to file one is because she had 20 people on hers. So if she was only going to testify herself, she wouldn't have to file one either.
And
Right.
one
Let
of
me-
the problems, excuse me,
Let me have an answer. Did you ask me a question? So the rules do apply for everyone.
Thank you.
And what I normally do, if I feel that there's a violation of the certificate of readiness, I allow the reason for a certificate of readiness is so that everyone is on notice on who they're going to call as witnesses. And so that there's no surprise, there's no discovery violations, that everybody knows, because this is a civil proceeding, that everybody knows what the evidence is going to be, or at least who they plan to call. When a party violates the certificate of readiness, the court can do what they think is in the best interest for the trial and for the child in making their decision. So what I normally do as a sanction is I will either give the parties an opportunity, if there are surprise witnesses that they were unaware of, to take some time to do a mini deposition before the trial starts. Where I would step off the bench for about 30 minutes and allow parties to talk to the surprise witnesses so that they can find out exactly what their testimony is going to be or what they're going to do. The other option that I give the party who was not the recipient of the certificate of readiness, or the party who did not do the certificate of readiness, is that I give them an opportunity to continue the case, to give each party an opportunity to submit the certificate of readinesses and then to be prepared for the trial. In this case, the only witnesses that the state and the guardian ad litem and the father's attorney are planning to call are the parties. And so there are no surprise witnesses. There's just the three parties of the case, which are the Department of Children's Services, the mother and the father, I'm assuming. I will be happy to take about a 30-minute break and allow you an opportunity to depose informally the Department of Children's Services caseworker, as well as the father, to see what information, if there's going to be any surprise or anything like that. Or I'll be happy to give a continuance so that they can follow through on filing an actual certificate of readiness and presenting that, and then we'll try it all again. So those are the options for the sanctions that I'm willing to do at this time. Which one would you prefer?
I would actually prefer, well, I don't know, can you give me, because you question witnesses differently, and I see you're complying with the rule because it said that failure to comply could result in sanctions. So I appreciate your explanation. I appreciate these two options.
In every case I've had since I've been on the bench in 2004, when there's been a violation of a certificate of readiness, I have given the parties that did not receive the certificate of readiness the opportunity to depose their witnesses or to request a continuance so that they have an opportunity to get the certificate of readiness. In this case, I'm not sure if that's really necessary, because I think we know what the DCS person is going to talk about, which is what's in the petition, and I'm assuming we know what you will talk about, and I'm sure we know what Mr. Guider will talk about. But I am willing to do what I normally do on each and every case, so that there's not a belief that I'm treating anybody differently. That's how I normally do it.
Well, and I also am concerned, I have concerns about, I heard Ms. Carlton say, I hear this over and over again, dealing with DCS, and there's a bill in the House right now to, proposing that DCS be abolished. And I met with John DeBerry from Memphis and discussed this. And there's a problem when there's one set of rules that are supposed to be applied equally to everyone. Yet, and this is my experience in DCS too, there are practices that apparently supersede the law, local rules, Constitution,
Nothing
and even
superseding.
DCS's policies.
Okay, let's move on, because whatever their policies are and everything, my rule is what I just told you. So which one do you want to do? Do you want me to give you 5 minutes to think about it? I'll start off.
I really think that, because I know you question witnesses differently. If they called me, they would be questioning me differently than if I was questioning or giving my own testimony. Same thing with Mr. Gadare. They would be asking him different questions. I think a continuance would be most appropriate in this case.
Okay.
And we are scheduled to come back on Wednesday. So, and also, however, Ms. Getz has some documents that,
She's not called right now, so I'm not going to piecemeal. So I'm either going to continue everything, or I'm going to go ahead and do the trial.
I think she only actually needs the documents, and that was her intention, and maybe so Ms. Getz didn't have to come back again on Wednesday, we could just get those documents.
And Your Honor, respectfully, we need to object to that because Ms. Hubble was restrained from having any documents by via court order from our August or September court order. And so the school district is somewhat confused as to what they can release and what they can't release, because there's been communication from Ms. Hubble as well as in violation of that court order with emails to parties at the school as well. So I would prefer that we leave that all, because then we'll be getting into a contempt issue, Your Honor.
All right. So if you want a continuance, I'm going to continue everything.
well, can I just ask for clarification? Does your restraining order trump my constitutionally protected right for due process?
Yes, it does.
It does.
Yes. If I've done a restraining order for whatever reasons, it does. There's
So
a basis for me to do that. So yes, it does.
It
So
prohibits
if I
me.
restrained you from
Okay.
getting records from the school, then yes,
So
you
you're
cannot
saying
get
that I
records from the
cannot
school.
use the records for my defense? Can I make an oral motion that you lift the restrictions in order to allow me to defend myself against these allegations, which, I mean, very serious.
What I can do is I can look at the records in camera.
Okay.
If there are things that I think that would be beneficial for your defense, I will release them to all parties.
Okay, but we have not done opening arguments. You don't even know what my defense would be.
I certainly don't. So I'm either going to continue everything or I'm not. I will take the records and put
Okay.
them in camera.
Okay.
Only I will be able to look at them, no one else. And then if I think that they're appropriate, based on when we come back, what your defense will be, then I will parcel them out as need be.
Okay, so basically, she doesn't have to come back on Wednesday.
Correct.
Okay, and we may or
Now,
may not.
We're just coming back on Wednesday so you can depose the witnesses that the department plans to call.
There's a law. There's a law that is, in fact, there's a recent.
Let me do
Change.
this. Is other than their records, is there anything else that Ms. Getz needs to be here for?
Well, I mean, I believe that Ms. Hubble is restricted from contacting the school and asking for records, is it not? And I think Ms. Getz's testimony, as I've talked to her this morning, is that she's blown up the school's phone, calling all the time.
That is, I strongly deny that. And if they're going to make that allegation, then we do need Ms. Getz to come, because I have not
I'm
been
not
calling
going to bring
them.
Ms. Getz back. Ms. Getz, let me go ahead. If you will hand over the records that were requested. As of right now, Ms. Getz, there is a restraining order that does not allow Ms. Hubble to have contact with the school. And that's a legally binding order. If she does, then you all have you can, legal means to have her to stop doing that, that would be
Well, Your Honor, I would like some
calling
clarification.
the police, and I'm not sure if that would make a difference. Right.
I would like some clarification on that, because the way I read this order, the restraint was not put on the school, the restraint was put on me. So I'm confused about
You to
how.
not contact the school, is that what the, let me find the restraint. Can somebody tell me the day of that restraining order?
This is September order, Your Honor, I believe.
Who was your clerk? Was it Sheree?
No, yeah, it was Sheree.
When did you start with me?
September 2018 was the order. I think it was from,
Yeah, it was Sheree.
yeah.
Okay, I have an order from July 30th that you
I signed on September 10th, maybe?
know.
It was
Yeah.
the August
It was
17th.
it was
August
August when the
17th
order was-
hearing.
Okay.
But I would like for you to read the, actually explain that your intention, and I would, just as a citizen of the state of Tennessee and a resident of Davidson County, I just seriously want to understand how this works and how,
And so
you
the
know.
order says specifically, Ms. Getz, this is for your information to make sure you understand as well. It is ordered, adjudged, and decreed that all contact between Dilara and her mother is suspended. This is to include contact through phones, fans, rocks, calls, school visits, appointments, visits, letters, and any other mechanism which would allow contact. The mother is also restrained and enjoined from having any contact with the school and or receiving any of the child's school documents or paperwork.
Okay, so that is a restriction. When you enjoin correct me if I'm wrong, that restraining order is a restraint upon me. There was not a restraint. You did not issue a restraining order upon the school. You issued it to
So
me.
you want the school just to, no, because you're not allowed to receive any of the child's information.
But how can you enforce that? And if the father and
I'm telling the school representative right now that you are not allowed to receive it, so. you
however,
can't.
I do.
That's the court order. I'm going to let Ms. Getz go back to school now, so she's got a number of wonderful children that are getting ready to celebrate spring break and wind down the week, and so she needs to be back. Is there anything else that needed Ms. Getz to be here for? So that is the order of the court. If that changes, I'll make sure that the guardian ad litem or someone lets you all know.
She had also subpoenaed our principal who's sick this morning, so I will share that with her as well.
Thank you.
And she should do the same thing, bring the records. I mean, these are rebuttal. These are rebuttal exhibits, because we've seen before how the father has made false allegations, and the only way I was able to disprove those allegations is through the school records and through the counselor's records and the information that you enjoined me from receiving. So it's there again. It gives the appearance of bias and impropriety, and I think those would be grounds for you to recuse yourself. I mean, these are serious constitutional issues that are at stake here. My parental rights are fundamental liberties in the state of Tennessee. I don't know if you realize that or not, but they are. And
I'm sorry, may I please be excused? I need
Yes.
to. Yes, thank you.
Okay.
And
I'm going
I-
to excuse Ms. Getz too. You are excused too. Thank you.
is Ms. Frazier going to come and bring the documents under the same conditions that you be able to look at them in
I will.
camera?
I will have the guardian ad litem to pick them up
Okay.
under seal, or they can just, y'all can mail them to the court under seal.
Okay.
Will you give her information where to
Really
mail it
important,
to?
it's under seal. We'll just make it-
And another problem is that I subpoenaed Mr. Gadare and asked that the child be allowed to come. And I've looked at I mean, this is a neglect and dependency case, and there are rules that apply, and there are rules.
How old is Dilara?
She is 10 years old,
Okay,
and
so she's still under the age that she has to come and testify.
but
So
she's
we'd have to
not.
have a separate hearing
children,
about whether or not she.
children younger than her have testified.
Yeah, and that's usually, that is a decision that the judge makes based on testimony from all parties and whether or not she should be able to testify.
Well, you won't be able to,
So there would have to be a separate request from you asking me to allow her to testify, to come to court to testify. We've done this before, and we had school people and a whole lot of people, and at that time, I think that was a year ago.
It was 2
so she
years
was
ago.
younger.
It was 2
I made a
years ago.
determination that she was not. We did not need her to testify, and
this is a different proceeding altogether. These are different allegations.
so there needs to be a different request.
Well, the first time around, I did the county regularly. We did the same thing I did this time around, and the other side had to, guardian line or somebody had to quash the subpoena. There was a hearing, and county regularly came on the subpoena quashing. But I really feel like my daughter has constitutionally protected rights that are being ignored. There's serious, they're talking about me being the cause of psychological harm, and the guardian ad litem even said, we do agree that the child has been harmed psychologically. We just disagree on the cause of it and who the perpetrator is. And I believe that Dilara's testimony is critical.
Okay, so you are testifying, arguing something. There are two things I need to determine. You have made a statement for recusal saying that you believe that I am biased. Let me hear a response from Ms. Carlton.
I haven't heard any basis for that, Your Honor.
All right, Ms. Mader.
I would agree, I haven't heard of basis.
And so tell me your basis again, or why you think I should recuse myself.
I believe that basically I am being set up. You're excluding my testimony and evidence that would vindicate me, and you did that on purpose. I have never seen you do anything similar to this to the father. I have seen you over and over again ignore anything positive about me, and everybody else has seen it too who's not within this, everybody out in the outside world, the taxpayers who are paying for this abuse of my child over year after year after year. And I had a judge.
These are the same taxpayers who, about 3 years ago, when I told you not to post things, and you did not follow the court order. Do they know that every time we do a court order that you don't follow the court orders?
Well, first of all, that is not true. I started this case following every court order, including ones that I felt were detrimental to my daughter's well-being, such as stopping me from homeschooling. They insisted that it was in Dilara's best interest to enjoin her from homeschooling. She went to public school, and she had the problems that I predicted she'd have in my answer to their petition. And everything, all of, and we had the guardian ad litem come in and say, ask me what gives me the right, what credentials do I have, as if my constitutionally protected right, parental rights, weren't enough. She asked me what qualifications I had to usurp the authority of third parties in determining what is in my own child's best interest. And nobody was concerned about her. This whole proceeding has gotten worse and worse. It appears to me, at the beginning I was following orders. I was, and they kept putting more orders on me, and like gag orders. I'm like, why are they putting gag orders on me? I'm not making derogatory remarks about the father. He can do no wrong in this court. And I've had a judge who's a friend of mine, and before he died recently, he said that it appeared to him as a judge and a defense attorney that it appeared that your personal feelings were clouding your judgment. And there's been a lot of people in the community say that. So I strongly believe that it does give the appearance of bias. And it's the appearance, whether you're biased or not, it's when everything that supports my position, you don't You don't note that. Everything he does wrong, you were told about him, he's cut Dilara off from her sister. He screamed at her, and when she was upset from not seeing me, he hit the windshield of the car, and she said she thought he was going to kill her. Nobody's concerned about that. Nobody's concerned about her being cut off from her mom. The focus is not on my child and the child's best interest. Nobody appears to be going by the guidelines. There are guidelines in the law for determining what is in a child's best interest. There has never been any evidence whatsoever, as required by law, to restrict my parental rights.
Your Honor,
Not one
there
time.
you-
I've been asking for years, where's the evidence? And they're trying to make that case, but as you'll see, they're allegations. There's never been any connection. And the expert witness testimony in our last trial
All right, I'm
was
not sure
ignored.
where we're going. Let me say this too, and I should have said this before. This is a proceeding that is a neglect independent proceeding. Because of that, this is a closed proceeding. That means there is no one that is allowed to hear this case outside of the people in the courtroom unless given permission by the court. I am saying this to you, Ms. Hubble, because you have a habit of posting proceedings on social medias or tape recording. So I'm telling you now that that is against the law on a neglected dependency proceeding, which this is. And so I will require someone to file a petition of contempt if there is any recording of this proceeding outside of the court's permission. Do you understand that, first and foremost?
Yes, I do.
All right, so let me make sure you understand. If you are recording at this point by any means other than the court recording, you should turn that off now.
But it is being recorded.
It is being recorded.
Okay.
All right. Secondly, there is to be no posting of this recording after the fact. Do you understand that? It is against the law to record anything of neglect and dependency petition. Do you understand that?
Is it
Neglect and dependent proceedings are closed proceedings according to the Tennessee Code annotated statute.
okay? Well,
They
this-
are closed.
So-
They are only allowed to be open by permission of the court. I am not giving any permission for this proceeding to be open, which means no one outside of who is in this courtroom now will be allowed to hear this hearing. That means it is not allowed to be posted. Do you understand that?
Yes, I
All
understand
right.
that.
Thirdly, as much as I would love to be off this case because it bogs my docket and it takes a lot of time, I am not going to recuse myself from this matter. I have been fair on both sides to all parties. My job is to listen to every side, and I have done that since the first day I've had this case. I have listened to every side, and I have given things, I have taken things away based on only the evidence that I have heard. So I do not think that there has been enough showing for me to recuse myself, even though it was at the tip of my tongue to say, absolutely, let me get off of this, only for court's convenience, not because of fairness and unbiasedness. I am completely unbiased in this matter. I am completely fair, and I have been fair from day one. To further state the fairness that I have shown you, Ms. Hubble, in the April 19th order of 2018, having found no material changes circumstances, which was the request that Mr. Guider asked for,
No,
I
that was-
denied his request. Denied his request for a material change in circumstances. The court finds the previous custody order will remain in place. However, in the previous order, mother would be allowed to exercise unsupervised visitation once an agency recommends it. In this case, Ms. Ballard, with Progressive Families, has determined that it would be appropriate for mother to have unsupervised visits as long as there are in-home services in place. Therefore, the court will allow unsupervised visits on a gradual basis. So despite what you have said, I did give you the opportunity to have unsupervised visits. What happened after that is what I'm going to hear next. I am going to deny the request for a continuance. We're going to move forward. Ms. Carlton, do you have any opening statements that you would like to make? You can have a seat, Ms. Galvin.
Your Honor, the department would like nothing more than for Ms. Hubble to be able to have unsupervised visits and to have a relationship with her daughter and have contact with her daughter. We always think that, well, not always, but in this case, we think it would be in the child's best interest if Ms. Hubble would abide by the guidelines that have been put forward. She does not do that. Some of the things, I'm not sure how you want to take up, because our petition is strictly based on the psychological harm that we've alleged, and that comes from Ms. Hubble attempting to reach out to Dilara with fans, by putting chalk on the sidewalk, by going near the school, by pushing those boundaries constantly, and reaching out to the child and trying to ensure that she still has contact with her when in fact she's prohibited from doing so. And the reason why we know that she has stated over and over and over again that she does not intend to comply with the court's orders, and as recently as last week, said that we would get into her house over her dead body, or when hell freezes over, I'm not sure which one of those things. And the testimony will be that she continues to try to circumvent what the court has asked her to do and what we have tried to get her to do so that she can have more contact with Dilara.
All right. So theoretically, Ms. Mader, are you all still on the case? I guess dispositionally, but for adjudication, it does not.
For adjudication, I was appointed to Dad because he's a parent.
We always assume.
Because we kind of
We
discussed
did.
that before,
Okay.
because she non-suited her petition, and then you made the determination that even though she non-suited because he is inevitably involved in the case as a parent of the child, then he would still get counsel and we would
Okay.
still be parties to the case.
All right, go ahead, open the statement.
You heard extensive testimony even in August of this past year regarding some of the circumstances that were going on. As recent, even this year, the mother is still attempting to reach out to Dilara, and it's not just about violating the order. I think what the court really needs to look at is the method in which she does it, that is psychologically harmful to Dilara. And things like doing things at the school and the fan and sneaking messages in, and they are things that are psychologically damaging to a young child who feels like she is constantly thrust in the middle of the litigation due to her mother's actions. All contact is suspended for the mother at this point, and we would ask that that order remain in place.
All right, Ms. Hubble, opening.
Well, Your Honor, as I have said, there has been zero evidence of psychological harm. If there had ever been any evidence of psychological harm, it would have been brought up in the custody modification trial. We had a expert witness testimony, child psychologist expert witness. There was absolutely zero evidence. None of her testimony supported any allegation that any of my actions whatsoever had harmed Dilara in any way. I expect there will be no proof today that that I've ever any of my actions have harmed Dilara in any way. I believe the proof will show that it is my absence. It is the interference, the relentless interference of the other parent in his attempt to alienate the affections of my child and to misuse the legal system to deprive me, my daughter, my family of constitutionally protected rights under several amendments of the United States Constitution and corresponding rights in the Declaration of Rights under the Tennessee Constitution.
All right, thank you. Ms. Mack?
Good morning, Your Honor.
Good morning. You can stay there.
And the time frame that the court will be looking at is not just only the time frame of April 30th, 2018 up until currently. The allegations in the Department of Children's Services petition is psychological harm. The proof that has been shown throughout this case, through a preliminary hearing, there's a video, there's tape recordings of the mother soliciting the child, engaging the child in communications about how to solicit other people to change their opinion and their decision. That is a part of the court record from the preliminary hearing. The proof would show that the mother has on numerous occasions since, let me start here, May 1st, 2018, we have been to this court now on numerous occasions from May 1st to May 8th to May 15th, June 12th to June 14th, July 3rd, July 27th. Then we come in on August 17th to suspend the mother's contact with the child because she's doing the very thing, Your Honor, that the Department of Children's Services alleges in their dependent and neglected petition. And the court, based upon that, suspends all contact. Your Honor, it would be my position as guardian ad litem. Ms. Hubble proves up the case on her own admissions, her own actions. In fact, the proof would further show during the CFTM on last week, Ms. Hubble admitted that the child is going through psychological harm. And I said to her, we finally agree on something. The only thing that we don't agree on is who is the perpetrator of that psychological harm. Your Honor is aware from even prior to the Department of Children's Services petition is that even at the child's first elementary school, the child was suffering some social issues. There's been numerous amounts of testimony. However, let's go into April of 2018 when the child now has not only just an IEP for being gifted, but now has a functional behavioral plan because her behaviors had become so violent and aggressive that she was abusing other children as well as broke a teacher's toe. That has been litigated. But those behaviors began to escalate anytime this child had contact with her mother. But yet Ms. Hubble, looking at her constitutional rights, still chose to discuss this case with this child. That proof, Ms. Hubble is our best witness. The state doesn't even have to call anyone but Ms. Hubble. What's in Dilara's best interest, Your Honor? It's in Dilara's best interest that she continues with Tennessee Voices for Children, probably long term, because I believe the dad is going to need that kind of help, whether it be the Department of Children's Services keeps their case open for the rest of her natural born minor childhood or not. The issue at the end of the day is, will Ms. Hubble ever change, whether or not this court finds that she's committed psychological harm or not? Whether you sustain or dismiss this petition at all, nothing will change. Ms. Hubble's constitutional rights are more important than Dilara's, and that's at the end of the day. And here's where we are, again and again. Even the CFTM, Your Honor, proof will show that CFTM, which was confidential, is now on Facebook. It's live because Ms. Hubble put it there. Even though the court asked her on numerous occasions before, please stop posting private and confidential things. She doesn't care. Dilara is not important. Dilara is not important. The only person that seems to show that they care about Dilara is Mr. Gadara, sacrificially caring for this child. It will be my position, Your Honor, that the court sustain this petition, but it will be in Dilara's best interest that this no contact remain intact until Ms. Hubble finally gets it, and I don't think she ever will. Thank you, Your Honor.
Okay, first witness.
Lady Hubble.
All right, come on over to the chair, Ms. Hubble.
May I ask from here, Your Honor?
You may.
Ms. Hubble, when is the last time that you spoke with Dilara?
I believe it was July whatever the last visit with July 14th, maybe 2018 was the last time I spoke with Dilara.
And since that time, have you been to the school and put up signs so that Dilara would see them?
No, I have not.
Have you written on the sidewalk with chalk so that Dilara would see them?
At the school? No, I have not.
Well, anywhere.
I have written on a few months ago, back in the fall, I think it was the last time I wrote with chalk. And I hope as many people as possible saw them, including Dilara.
And what did you write?
I think I wrote hashtag Free Dilara. I'm not exactly sure what I wrote. I've written lots of things over the past year, so I'm not exactly sure what I wrote last time. I think it was Free Dilara Gadare or Team Dilara.
Okay. And you provided, at the last time that you visited Dilara, you gave her a fan that you had made that said Free Dilara.
No, I did not.
How did she get the fan?
She didn't get a fan.
So, when you say Free Dilara, what does that imply?
It implies that she is being restrained and prevented from exercising her constitutionally protected rights. She's been cut off from all of her family, all of her friends, and she's not allowed to use the phone. She's not allowed to. She even told me that if she called me, her dad would take her iPad away. So what's your question? I'm sorry.
So you feel like she's being held captive?
Yes,
With
absolutely.
Free Dilara, I mean.
Absolutely. I believe children should be free to love both parents, and she's not. She's not given that freedom. Psychologically or physically, she's not given that freedom.
And is it your position that you think that it's in Dilara's best interest that you keep telling her that?
That she has a right to love and enjoy relationships with both of her parents?
Who tells her that she's not allowed to love you?
I believe her father is giving her
Objection,
that.
Your Honor, cause for speculation.
Also, it's time.
Well, how am I supposed to answer that if I don't have? I'll okay, never mind.
Have you placed signs on the sides of the road to the school that say Free Dilara?
A couple of years ago, I think I did. A year and a half, 2 years ago.
Did you show up at the park when Dilara was there with a sign yelling?
I absolutely did not. That never happened. Never happened.
So on what basis did Mr. Gadare get a restraining order against you? It's all lies?
Yes, pretty much lies and the difference of opinion. He thinks that, he's got his opinion, he expresses it, and lies and makes misrepresentations. That's what he's been doing from the very first petition he's filed. As in my answer to the very first petition he filed, I've shown, and in the trial I've shown, disproved his allegations against me, and that's how I got the order of protection. But I'll be asking him about that myself, so you can hear straight from him.
And what methods have you attempted, let's say in 2018 and 2019, to reach out and make contact with Dilara?
What methods?
Yes.
Your Honor, I object to that on the relevance. She's already asked me about making the signs, the chalk. I think that's basically been asked and answered.
I think she can ask what other messages other than signs and chalk. What other methods have you tried to use?
I have, hold on a second. There was a social media that she said it's the only one her dad would let her be on, and I posted a video that I hoped that she would see on that.
And are there other apps that you attempt to communicate with her on? What is the name of the social media that you're referencing?
It's called TikTok. It used to be called Musical.ly when she asked me to set up an account.
How did she ask you to set up an account?
She said, will you set up a Musical.ly account? I really want you to do a Musical.ly account.
So this was when you were still allowed to see her.
It was on a supervised visit with Angela Hilliard.
Okay.
She specifically asked me, I'd never heard of it before, but she's very insistent.
Have you asked other people, neighbors, friends of Dilara's, other acquaintances to reach out and say things to her or spy on the family?
I have reached out to people and let them know that there's an issue, that she's being kept from me, that she has expressed that she feels like she's being treated unfairly, and that nobody cares or will help her, and that there's just were concerns, and I've reached out to some neighbors and people in the community to just, if you see anything that's concerning, if you can give her an encouraging word, anything like that, just to be aware that there's a problem. This is a child who is very much at risk, and I think neighbors should be watching out for each other, and I don't know that any have contacted her.
But you've attempted that.
Yes, I have made as many people in the city and state aware, and the country and the world, that my daughter is at risk and her needs are being ignored over and over again, year after year after year, and the public has I feel like they have an obligation to speak out against it.
Have you sent gifts that had messages contained inside for Dilara?
I sent a book, I think it was before this last order, that had I wrote an inscription to it. I can't think of anything else right at the top of my head.
An inscription in the book?
Yeah, I was actually I'm confused. I don't know which book that was. I know I had a Grimm's fairy tale book. I've had different books, and I like to inscribe, I hope you enjoy this, something like that. So I'm not. And then all these years, things that I've sent her, they run together. So I'm not really sure.
At the CFTM last week, when you met Miss Rucker, did you tell her to say something to Dilara so that she would know specifically what to tell, like a code word?
I was trying to. Dilara's had about 25 different strangers come into her life, and
Just answer my question.
Okay, answer your question.
Is there a code word?
I couldn't think of a code word. I just thought something that would. We don't have a code word, but just something that would. And she's not on your witness list, but I'll. She's not on my witness list either. She's your client? I asked you who your client was, and you wouldn't tell me.
My client is the Department of Children's Services.
Anybody
that works
including
for the
her.
yes.
Okay, so it's not the people who were in the.
It's anybody who works for the Department of Children's Services.
Okay. Well, you could have explained that in an email when I asked you.
I got tired of answering your emails.
Well, I'm sorry, but that's your job, isn't it?
Everything that is sent to you, Ms. Hubble, gets posted somewhere. So, I decline to have these proceedings and any communications with me posted all over social media. That's what you do, isn't it?
I try to expose as much of the
Put
corruption
my
as I
name
possibly
all over
can.
social media. You put the guardian ad litem all over social media.
That's correct.
Slander Mr. Gadיר.
I
all
have
over-
never slandered him. I have never slandered him in any way. Ever. Ever.
Answer.
I'm the one that's been slandered.
You've never slandered Mr.
I have
Gadיר.
never slandered. Prove it. Prove it.
Okay, well, hold on. Let me
Prove.
prove that. You have the other files?
Yes, ma'am, I have
Okay.
every file.
Slander means it's not true. Truth is a defense against slander.
Okay.
He's lied
Hold
about
on
me
just
over
a
and over
second.
again.
Hold on. Let me,
I just bring the whole box.
okay, that'll be perfect. I think Miss Mack is the only one that has been with me for a period of time. Can you recall one of, well, I'm going to, let me look through the exhibits of the Facebook post. Here they are. Is there some?
Yes, ma'am. We have a lot of posters, Your Honor.
Oh, Lord. Oh, let me look through this. Oh, you know what? They're at the Circular Court of Appeals.
That'll be-
And Your Honor, respectfully, the basis of that determination, Your Honor, would be Ms. Hubbell's perspective, because if she doesn't believe that it's slander, regardless if we proved to her that it was slander or not, she doesn't believe that she's slandering anyone.
Okay, but can I just read a few statements and see?
If you also provide the proof that it was untrue.
I don't know if they were written in the orders or not. It would be in order by Ms. Reese. Sarah Reese. I guess technically he is your Turkish enemy, huh?
Yes, that is true. That is a
Okay,
true
so that
statement.
is not slander because he is
And it's
your
constitutionally protected if it's not slandered. False statements are not constitutionally protected.
Turkish. I'm not sure if he's Turkish, but you're saying
He
he's
is
your
Turkish.
enemy. Okay.
He was born in Turkey. And he is my enemy, I think everybody would agree on that.
My apologies, Your Honor. Have we secured the recording that Ms. Hubbell had admitted to that she was doing earlier? Has that been securely turned
Oh,
off?
I didn't. She didn't admit that she was doing any recording.
Oh, okay.
She just said it is being recorded.
It's
and I
being
said
recorded.
yes.
Okay.
Oh,
And she does request those recordings in post.
She does, and I've told her what the penalty. Maybe I should explain what the penalty. But I'm not sure if it would make a difference. But I did tell her that someone could easily file a contempt. I think you're absolutely right, Ms. Mack. I guess the statements that she made, she could interpret them as true, or I guess she does, and so such as the one from November 11, 2015, when she posted an article titled "Rapist Dad."
I didn't,
With
that's,
an accompanied photograph bearing the following quote: The judge took my daughter from me and gave her to the man who fathered her by raping me. Now rapist has full custody of my daughter.
Your Honor, since you referred to that, that is Sarah Rice Digby misrepresented that. That was
That's
not
it.
my story. That was not my story. She said over and over again that I was accusing him of rape. That is not true.
Okay, thank you. And on November 9th, Dilaра's father is a batterer.
Yes, I believe he is. Emotionally, not physically, but he is. It's the mindset's the same.
And a Turkish terrorist.
Yes, I believe this is
Okay.
a different kind of.
All right, so her definition of slander is different than what I think the legal definition of slander is. So go ahead and continue. I apologize.
A batterer is, you don't reference it being emotional battery, but you don't think that that's slander to say that he's a batterer.
No, because if you have the, if you've got any experience in domestic violence field, you understand that battering, it can have the same emotional effect. There, you can batter somebody. We talk about people. Oh, they beat me up in that meeting. I hear Steve Glover talking about, oh, we get beaten up.
But that's not the common meaning for that, is it? Do you
It
think
is.
that-
I
do you
believe.
think-
No, I believe it is in domestic violence circles. Battering, the emotional abuse comes under the same
We're not
umbrella
talking
term.
about domestic violence circles.
I-
Do you think that it's in
I-
Dilara's best interest to believe that her father is a batterer?
I think it's in. I think she feels. She has expressed.
Objection, Your Honor, calls for speculation.
I'll sustain.
Okay, I have heard her say.
Objection, Your Honor, testimony from my client. Your Honor.
This is a neglect and dependency, and the statements of the child are an exception to the hearsay rule.
Unless there are allegations of dependency and neglect, Your Honor.
Unless
Overall, I'll let her say it.
she has said to me, and I intend to, this is on recording, and I think the father can also confirm them. She has said, and it's also been reflected in the testimony of Latara Ballard, although she did not go into the specifics.
I'll sustain on anything that Latara Ballard has
Okay.
said.
No, I'm saying what Dilara said in her presence.
No.
She and what Dilara has said on the recorded phone calls. She has said that her dad treats her unfairly. She said that her dad throws her around. She said she was afraid her dad was going to kill her. She has said these things, and I believe those are indicative of her feeling oppressed, battered, trod upon, disregarded. I believe that it is in my daughter's best interest for me to let her know that I acknowledge her feelings, whether the perspective, and I have talked to her. In talking to her, I have told her, my dad was throwing me around, and I'm like, well, I just tried to laugh it off. Well, you used to like to be thrown on the bed and stuff, and she was offended. She was hurt. I could see that she was hurt, and she said, "Don't you care?" And I thought she was going to start crying, and I apologized to her this summer after he broke the windshield, hitting it and making her feel like he was going to kill her. I told her this summer. I apologized to her. I said, if I have ever made you feel like anybody is more important to me than you, I'm sorry, and I will do everything I can to not do it again. Your father is not more important to me. Nobody's more important. You're the most important, and you need me. So she reached out to me, and I'm going to admit some testimony later. It was on my certificate of readiness. And the father can confirm some of these things, and you'll see she definitely feels disregarded. She said when she was beating up the people, the teachers and stuff at school, and biting. It was after she bit somebody, and I say, use your words, and she said, I do, but nobody seems to listen or act like they care. And all of my and. This has been on supervised visits, so there was a witness besides my daughter that she made these comments. And I believe that the father can also verify that she's made statements like that indicate that she feels like nobody cares about her, how she feels, or what she needs.
This is the one, a picture of a fan that we were discussing, right? That one
This is a
and
fan.
Similar ones,
Mhm.
there are some with similar messages.
And if you look at my Facebook page, there's a picture of the Governor Bill Lee holding one.
What does
And
that, how
there's
is that
one-
relevant?
How is it relevant? I'm trying to get help. I'm trying to get her attention
When you
since
say-
DCS refuses to get her any help.
When you say bring her home, she is home.
She has 2 homes. She's only at one.
Again, answer this, do you believe that it's in her best interest for you to keep on telling her that she is a captive, that her father does not have her best interest?
I thought I
Okay,
silenced
let
it.
me-
Excuse me.
Let me confiscate that for the rest of the hearing. You'll
Okay,
turn it off.
Let me silence it first. So it won't go off again. There you
You'll
go.
go ahead and make sure it's turned off. Thank you, Ms. Sonnet.
Could you repeat the
Do you
question?
believe that it is in Dilara's best interest for you to communicate to her that you believe that she's being held captive?
I believe it's in her best interest to validate her feelings.
Check that one, please, make sure it's off as well, before you lose it too.
Just
Or
off,
volume
off.
windows.
Let's turn it off.
Yeah, let's turn it off.
I think this one was
All
silenced.
y'all check your phones, because I hate for you to lose them.
Yes, ma'am.
I believe it is in her best interest. I'm pretty much limited in, because I'm limited in direct contact with her. But I think it's absolutely in a child's best interest to feel like they're, I think it wasn't turned all the way off. Maybe you could
It was
push-
going, it was powering down your
Oh,
phone. Keep going.
So do you remember a CFTM, the first one that you and I were at together? And I believe Mr. Kadir was on the phone. There was discussion about this. And you were asked, or you asked the question, what is wrong with this man?
Mhm. I don't recall that, but I still say, how can you connect the dots between me saying, okay, I acknowledge your feelings. I acknowledge your needs. I agree, your needs are not being met. I'm reaching out to other people so that they know that your needs are not being met.
Do you ever convey to your daughter, Ms. Hubble, that there are things that the court has asked you to do and that there's a reason why you're not doing them or you would be able to see her? Do you ever tell her that?
Well, since I haven't had any contact with her for 7 months, I can't recall a specific instance, but I did, but I don't believe that this is a situation where, and we're in a court of appeals right now, I'm appealing this. So we've got a disagreement over, whether it's well, I'm not supposed to be drag her in. That's one thing that I was saying when I said, if I've ever made you feel like your dad's more important to me, I'm sorry, and I'll try to not ever do that again.
Do you take, as you sit here today, do you take any responsibility for not being able to see Dilara?
Yes, I do.
In what way? What part of that is on you?
I got pregnant out of wedlock with a man who does not believe that children need mothers. That's my fault, and
Okay,
that
you-
rests solely upon me. I can't blame anybody else for that.
That is the only
Yes,
responsibility you accept.
yes, because I
Okay.
believe everything else
Well, after
I've
you
done
gave-
for her.
After you gave birth to Dilara, she was in your sole custody. So that had no impact on you having possession and contact with her.
Your Honor,
What
I
happens after
object
that?
to the relevance of this. I don't understand.
She's the one that brought up the relevance of her giving birth to.
I asked you the question, how am I at fault? I answered that.
I'm talking about the restraining orders, the protective orders, the criminal charges, this court's orders. Do you take any responsibility for those restrictions being placed on you at all?
No, and I believe they're unlawful. I don't believe they're in my daughter's best interest. I believe every restriction that has ever been put on me has been not to protect the child, but to empower Dilara's father.
And you have said repeatedly, have you not, that you intend to continue to break those orders?
I intend to continue to act in my daughter's best interest.
No matter what that entails?
As long as I'm not treading upon other people's rights, I believe that under the Constitution of the State of Tennessee, Article 1, I think it's Article 1, Section 1 or 2, maybe it's Section 2, where it says that the doctrine of non-resistance to arbitrary power and authority, or oppression and arbitrary abuse of power, whatever, something like that, is detrimental to the good and happiness of mankind, and it's harmful. It's slavish, absurd, what do they say, slavish, absurd, and detrimental, or something like that, to the good and happiness of mankind. So basically, when judges make orders that are arbitrary, like I said, they've never...
That you believe are arbitrary.
Okay,
In your
what I
subjective
believe...
opinion.
Well, based on there's never been any connection between any definite proof of harm to my daughter from anything I've done. There's
Ms.
people.
Hubble, this has been adjudicated already. There are orders that say that she is dependent and neglected.
No, they're not. I'd like to see
Or
that.
that it's
That has never been a finding of this court, Your Honor. I'd like for you to take a note of that. That's not true.
It was mostly
It was
all
custody
issues.
Okay.
I've never been
So there have been
adjudicated.
findings that-
There's never been any findings of neglect or dependency.
Okay.
Only by DCS. DCS made that findings, but no judge has made that finding. That's what you're trying to do right now.
Exactly.
But it hasn't. That's not.
Okay,
This has
but
never
you
started.
lost custody because it was determined by the court that it was not in her best interest to have contact with you. Was it not? But you think, your testimony is that that's arbitrary and you don't have to pay any attention to it, correct? Yes or no?
I believe that the orders that have restricted me are unlawful. I'm appealing them right now. And I believe that following those orders would harm my daughter worse than she's already been harmed. And also would harm her father more than he's been harmed. And harm me and it's just
Okay.
to everybody.
You've already taken one order all the way up to the Court of Appeals and it was sent back down and judge was upheld. Except for one minor restriction about the social media, correct?
No, that's not correct. That's not correct. Do you want to go over a copy of that order from the Court of Appeals opinion?
Take judicial notice. I know it was upheld.
Okay.
I think constitutional violations of free speech. I think that especially I don't know if you're exempt also from an oath of office that to support the Constitution, but I mean that constitutional issues are not minor, and I'm very offended that you would even state that constitutional infringements on free speech that they're minor.
But Ms. Hubble, you have raised this issue already with the Court of Appeals, and they did not find in your favor, did they?
They did
On the constitutional.
Yes, they did. They said they did.
Did they
found
get you custody back of your dog?
they didn't. There was still an order of protection in place.
And it's still in place now?
The order of protection between me and my daughter was in place when we started the appeal, but it's not in place now.
Is there, you stated, I've been in your presence in CFTN where you have stated that no matter what happens, if you have to, you'll just wait till Dilara is 18 and see her then. Is that not right?
I have said.
Because
when
you have
any-
no intention of obeying.
Unless I will change my position if and when somebody can show me how it is in my daughter's best interest for me to comply with orders that I believe are against her best interest.
That you believe are against
Yes.
her best interest.
Yes, I go by my conscience, because I'm the one that has to live with the consequences of it.
Those are all my questions. I
All
think
right.
that says it all right there, Your Honor.
All right, Ms. Mater, any questions?
Do you want me to stand up there or?
You don't have to. You're fine right there unless you feel more comfortable standing.
Ms. Hubble, have you made a post on Facebook in which you reference Dilara staying alive 2 more months?
Something, do you have a copy of that? You could read it exactly.
You said, I think she will stay alive 2 more months.
I guess I did.
What were you referencing prior? What does that mean?
Well, I'll go into details of that when I'm giving my own
I'm asking
testimony.
you right now.
It means that after she's made at least 3 expressions of suicidal ideation that I know of and that were made, that were addressed in this last custody modification, I feel like, and we discussed it, it was brought up with the visitation supervisor, and I'm just concerned when an 8-year-old expresses suicidal ideation, and when an 8-year-old or 9-year-old posts very disturbing drawings on the internet that say help, and as a character with a knife sticking out of its chest, and when she's asking adults to please kill her, I believe that, especially when we see 8-year-olds definitely she's 10 now, she's in 4th grade. Some children, I know one a little girl in Alabama killed herself, 4th grader, 10-year-old, just like
Objection, Your Honor,
Dilara.
relevant.
It's relevant to her question. She's asking me why I'm concerned about my daughter, and I'm answering her question.
Well, I specifically was asking why you put that post up, and it's because you're concerned that she is suicidal. Is that?
Yes.
Okay. So, do you think that if she were to see that you posted that, that would create a negative response from her?
Your Honor, I object to that. It calls for speculation.
I'm just asking in her opinion, because she seems to give all this testimony about how she knows what's best for Dilara. So I'm asking in her opinion, does she think that that would create a negative response from Dilara if she were to see that her mom had posted something like
All
that?
right, I'll overrule. You can answer that question.
What are you doing?
Overrule the objection. You can answer
Well, what
the
are you
question.
doing on your little device there? Is that,
Answer the question, Ms. Hubble.
would you ask the question again?
If she were to see that you had posted that, do you believe that would create a negative response from Dilara?
I do not believe it, that it would create a negative response, and, but if somebody could show me that it's likely to create a negative response rather than a positive one, I think it would be neutral at worst, positive at best. I don't see any way at all it would be negative, because she knows that I'm addressing what she's spoken out about. So I mean, my intention is always for her best interest.
So you think that you making a post that would intimate that you think that she's going to kill herself would not in any way maybe make it more likely that she would do so if she saw that?
No, and I don't believe there's any. I've read a lot about suicide and child suicide, and I have not seen any kind of research at all that would indicate that me acknowledging concerns that she's brought up, that me acknowledging them would make her more likely to, that would feed that ideation. I want her to know I'm trying to help her.
But the actual post just says, I think she will stay alive 2 more months.
It didn't say at least, or just says 2 months. Yeah. That was too, I'm just trying to get from one hearing to the next and get things set right, and based on things that she's told me and things other people have said that she's said and her behaviors and stuff. If I don't, first of all, I don't see how she would see that. And there have been appellate court decisions saying that there's no way to know if the child has seen it or
Object to
what.
this being non-responsive.
I will sustain. I can't remember exactly what the last question was.
I can move on.
Okay.
Did you give a gift to your other daughter to give to, a notebook to give to Dilara?
A notebook, like a journal?
Yes.
I have sent her a couple of journals.
Okay. When you sent one recently, in that journal,
I haven't sent anything recently.
okay, the last time you sent one, did you enclose a slip of paper which had your email address, your phone number, your text phone number, your address, your YouTube address, your Musical.ly account, and say, love will find a way? Is this something that you?
I did put that in a book I sent to her.
Okay. When, was that during one of your visits, or is that just something that you sent in the mail?
That, no, it wasn't during, it was something I sent, and I put that in there secretly. I didn't tell anybody about it, and I put it in there to make sure that, because I figured her dad, I was told that he goes over everything. It's like that further supports my view that my daughter is in captivity. I'm surprised that she doesn't have to bend and squat after she's seen me to see if I've sent something.
When
Or
was
squat and cough, that's what they do.
When was this that you included?
I don't remember when that was.
Would it be in the last 6 months?
It would be in the last 7 months. I don't know. I really can't say. I don't know when that was. I expect it was in the last 7 months, but I have no idea.
So after the court ordered that you couldn't have any contact, you then, based off what you just testified to, you secretly put this in the journal so that hopefully the father would not find it.
No, hopefully he would find it and make an issue out of it, which would show that he's treating my daughter like she's in jail, and he's cut her off from contact with her. Based on you look confused.
Yeah, so you basically, what your testimony is you did it to prove that he would catch it because he so closely regulates what goes on in Dilara's life. Is that essentially what you're pointing at?
Right. He treats her like she is in a high security, maximum security prison. And that also shows that not only am I not to contact her, but she is not allowed to contact me. And I think that's very damaging to a child to restrict her in that way. And I think it's so. But anyway, that's like the letters I've sent to her. I expected him to intercept them, and I expected him to intercept that, and apparently he did. I expected he would have found that, and I'm glad that came up today because I was curious. This is the first time I've got verification that he's gone that far.
Well, based off of what you're saying, though, it appears he needs to, because you tucked this in there. If he hadn't found it, then you would have been violating the court order by communicating with her.
Well, but I've already established that I will violate court orders if I believe they're in my daughter's best interest. So that's nothing, you know.
Since we were in court, have you given the department permission to come to your home?
No, I have not.
What about the guardian ad litem?
No, I have not. And I told her that she will enter my home or set foot on my property over my dead body.
Is it true that your home is being foreclosed on?
Yes.
When is that happening?
Well, it's set to go to auction on Wednesday.
Do you have any intentions of reinstating the loan?
I don't have the ability to reinstate the loan. I can't work. I mean, this is,
Are you gonna file for bankruptcy?
I don't know. I kind of doubt it because I don't have enough income to pay back, make bankruptcy payments. And what's the relevance of that, by the way?
What's relevant?
Well, is she making an objection?
Yes, I object on the basis of relevance.
She wants visitation reinstated where she lives in Delaware.
That is not, reinstating visitation is not on the docket, that's not the issue at hand. I believe it's irrelevant to this
I'll
case.
objection. I find it relevant.
Where do you intend to reside after Wednesday?
I haven't decided yet.
So, is it your intention or your desire to have visitation with Dilara, just not in your home?
I would like for my daughter to have a normal life like she had before we got taken to court. I would like for her to be free to enjoy my company and my nurture wherever I believe is a good place for us to spend time together.
Why? You do understand, however, that the court has said that until you allow a new home study to be done in your home where you are residing, that they will not allow Dilara to come to your home. The court will not allow Dilara to come to your home.
Right, I understand that. That's what the order says, which is the order that's being appealed.
The last time we were in court, you offered that Dilara had given you express permission to post her notes on social media, and that was supposed to be late filed with the court. Did you ever provide that to your attorney or file that with the court?
I could not find that one. That might have been one of the ones that I lost the files to, the malfunction in the recording device. However, it was one that the father should have recorded since it was called on the Google Voice. And
But you never filed that with the court?
I could not find it. But like I said, I was required to call through the Google Voice for the specific purpose of it being recorded, so the father has access to that recording. I think the Google Voice is a more reliable recording device than what I was using.
Were you clear regarding the fact that you were not to have any contact with Dilara's school?
Yes, I was clear. I was clear on that I was not to have. I was clear on being restrained from having contact with Dilara's school, but I was not clear on. I thought that there would be an exception in order to obtain exculpatory evidence.
Okay, so prior to you issuing the subpoenas to the school, so let's say prior to February of 2019, since August, have you contacted the school?
I have given them information, but I have not solicited information from them. So I did not believe.
Who did you give information to?
I don't remember. It's been a long time ago. Her teachers, I think. I don't know. I'd have to look through my emails. But there again, I was not contacting them to obtain information. I was giving them information I thought would be helpful or useful to them in meeting my daughter's needs. And I did not think that that was a violation of the order, since I was not contacting them to get information.
You previously posted letters from Dilara online, which were made part of the court record on August 17th. Do you recall that?
What now?
Letters that Dilara wrote that you posted online.
Letters that Dilara wrote. She didn't. I've never
No, I'm
received a
sorry,
letter.
letters you wrote to Dilara.
Yes.
Okay,
I have posted letters I wrote to Dilara.
okay. And do you recall at the last hearing that those were submitted into evidence?
Yes. Yes.
I think it was collective number 2 at the last hearing for the letters.
I think everything's gone.
To the Court of Appeals? I have copies with me.
Yeah, they're gone. They're gone.
I think I submitted my copy last time we were here.
Okay.
She's got a copy of it. I think I've got copies too. What's that? About the duck and the wasp?
Yes, do you recall in August of 2018 that you sent a letter to Dilara where you talked about a bunch of dead animals?
I sent her a card and I mentioned some things that had happened that I observed that I thought she'd find interesting. I just didn't, I didn't notice that I'd mentioned death 4 times, but
You
till it was
talked
pointed
about
out.
Bonnie, when you were walking Bonnie, who I'm assuming is your dog.
I recall mentioning the duck eating a vole, which reminded me of an owl eating a rabbit. I mentioned taking the dog for a walk, and the dog got a hold of a possum. I didn't know if it was dead or not. I remember saying that I had gotten stung by a wasp, and I had sprayed the wasp nest.
And that you let the birds out of vole had apparently drowned in their water trough.
The vole that the duck ate had drowned. And if it had not drowned and was already dead, the duck probably, if it could have cut the vole, it would have eaten it,
Okay.
whether it had drowned or not.
So, in this letter, you say, I keep checking my mailbox for something from you, hurry and send me something, and then the entire rest of the letter, other than the end when you talk about getting stung by a wasp, is the discussion of dead animals. You realize that?
It's not a discussion, it's mentioning what, it's
So that's it,
mentioning.
that's all you talk about.
Well, it was just a card. I didn't have a lot of, I thought those were things that had happened to me that were interesting. And I remember that when I went a year not seeing her, she had mentioned to me that she had seen a dead coyote. So I thought that,
I would ask that this be entered as I guess this would be the first exhibit today?
All right, before exhibit number 1. Any objection?
well, I object. I don't see how that is relevant as far as showing psychological harm to my daughter as alleged in this petition. What was written before that was this petition, the allegations in this petition were made in March, or I think this was filed end of April. So I object to the relevance of things that happened after this petition was the allegation of this petition. It does not support the allegation of the petition in any way, because
All right,
they're,
let me hear your response to her objection.
Okay, so I think she's making two different sort of objections regarding that being entered. I think the first would be that this was previously admitted at the restraining order hearing, which is what came out of the department's petition. So it would be relevant as to that, and dependency and neglect petitions are ongoing in nature as long as the substance, like we're not asking for a different finding like sexual abuse or severe abuse or something. So they would be ongoing in nature.
All right,
And then on top,
I'll rule the objection.
well, Your Honor, also, what she brought up, the motion that was heard in August was not the DCS motion. The motion that was heard in August was the father's motion to suspend my parenting time. I don't recall seeing anything that DCS.
I still think it's relevant. I'll overrule the objection. Well, Mark,
so I actually have a question based off of what you just said in your objection. So you don't think that this has anything to do with any psychological harm or anything like that related to Dilara?
No, I do not. I don't see, especially the allegations made that were the basis of this petition.
So there are two fans. You recall testifying last time we were here.
Excuse me, hold on just a second. I need to make a note. Okay, I'm sorry. Go ahead.
Do you recall a visit that you had with the child wherein you had free Dilara fans with you at the visit?
I went to the car and got one. That was not at the visit until I went to the car to get something else, and was hot in the room, so I brought one to give to the visitation supervisor because she was hot. I happen to have a fan in the car.
Are these an accurate picture of what the fan would have looked like?
It was similar. It did have her picture on it, and it did have her name on it. Don't know exactly.
Is this potentially
Is that the
front and
actual
back
one?
of the- yeah, that's what I'm.
Oh, that's the actual one. I can't say that it's not. It would the one because I don't. But if that was, I won't deny that that's the actual one, and I would like a copy of that. Oh, is this my copy?
Do you?
This is exhibit what?
I haven't actually.
Oh, I'm sorry. Okay, I'm sorry. But that was exhibit 1?
Yes.
The letter, the death letter. That was exhibit 1. Okay.
Do you understand why it might be psychologically traumatizing to Dilara to know that the whole world is looking at pictures of her and saying things and seeing messages like bring Dilara home or free Dilara or team Dilara? Do you understand why that might be psychologically damaging to Dilara?
No. In fact, I've seen zero evidence whatsoever about that being, I've heard, no. I think that's just somebody grasping at straws, making an opinion that I'm causing her more harm than good by trying to get her the help that she's asked for. I've seen zero evidence of that causing her harm in any way. And you don't.
Since your visitation stopped, do you have any personal knowledge of any issues that the child has had at school or at home?
Hold on. What was the question again?
Since your visitation stopped, so let's just say since August 17th.
July, yeah, July, it was in July.
Do you have any personal knowledge of any issues the child is having at school or at home?
Nothing specific, but I do believe she was troubled. I've had no direct contact, at school or at home. I don't know of anything.
Do you have any personal knowledge that any of the people that you talk to?
Hold on just a second.
that you talk to-
Hold on just a second. Yeah, that makes me, I gotta ask a question that.
you're doing that, I actually would like to enter this as exhibit number 2, the fan picture.
All right, any objections? All right, that'll be number 2.
Okay, what was the question again?
You had reached out to some people, you said in your testimony from when Ms. Carlton was asking you questions, and asked them to contact Dilara for you. Do you have any personal knowledge? of them that have done that?
I don't think that's what I said. I don't think I asked anybody to contact Dilara for me. I think I just said, if y'all see her, just be aware of the, I don't recall
Do you have
exactly.
any personal knowledge of whether or not any of those people you've talked to have actually spoken with Dilara?
I have no personal knowledge that any of them have. Yeah, I don't know if they have.
And just so we're clear, this strip that I'm holding up is the strip that you put inside the notebook
Could
that
you
you
pass it
sent.
this way? Let me look at it.
Thank you.
Can I take a picture of this for my records, or?
Why would you need to take a picture of it for your record?
Well, are you going to?
I have a
Photocopy?
copy of it on, I can email you a copy.
Okay, yeah, because I'd like to know what it said, because I'm
happy to email it.
okay, thank you. Yeah, this looks like, it looks like, okay, is this exhibit 3?
I would ask that that be entered as an exhibit number.
All right,
Okay.
exhibit number 3.
Let's see.
And I would ask that exhibit number 4 be this message that she posted, the couple posted. I think she was stay alive 2 more months. I think that you had identified that as something that was.
That's number 4?
I think that would be number.
All right, number 4.
She's calling. You're okay.
In the petition.
Yeah, I'm ready.
Oh, okay. Yes, ma'am. In the petition, they make allegations regarding, you posting about your daughter wanting to kill herself online. Have you made, other than the post that we just talked about, that you were intimating that, have you ever posted online that your child wants to kill herself? Dilara?
Yes. I've posted the, yeah, I'm not sure what all I have posted, but that was very concerning to me when I saw that in her IEP. She had first, back in 2017, that she had first expressed those thoughts. I made a big deal out of that because nobody else seemed to think it was a big deal. And she didn't, and I'd clarify, she didn't say she wanted to kill herself. She said she thought about killing herself but wouldn't do it. And she said she wanted to die, and she had asked people to kill her. I don't think I've ever said she wants to kill herself. But that's when she's expressed those other thoughts. That was, and when I read these stories about children killing themselves because they feel bullied and they're not getting, they feel mistreated by somebody. I believe I do have reason to believe that based on the way she's expressed to me that she's felt mistreated and that nobody cares, I'm very concerned about her.
Have you made a statement that to Dilara that was on a phone call that you had with her, that was, you miss me and I know you want to kill yourself because you cannot see me?
I don't recall that. I'd like, if there is, I don't recall that. If there is a recording of that, I think it should be played
Is it possible that you originally posted on Facebook and then deleted the phone call and the comments off of Facebook thereafter?
Well, if you can tell me when the date of the phone call,
This would have been in February 2018.
February 11th?
2018. I don't know.
February, I don't believe, I deny, based on my information and belief, that I ever made that statement. I would like to see definite proof that I made that specific comment.
Do you believe that to be true, though? Do you think that?
Do I believe it to be true?
Yes.
Your Honor, I object to that on basis of relevance, whether I believe, I mean, they have not even verified that I said that, and if I did say that, if I did believe it to be true, I don't see how that connects with, anything in the petition they're trying to support.
All right, your response?
Whether or not, I understand that she's not confirming that she said that or not. I'm asking about whether or not she personally feels that way. Whether or not she said it out loud to Dilara or not, I'm asking her.
All right, I'll sustain the objection if you rephrase your question.
Okay. Do you feel that she wants to kill herself because she cannot see you?
First of all, I don't believe she wants to kill herself. I don't believe she wants to kill herself. I believe she wants somebody to care enough about her to address this painful experience that she's been subjected to. What was your question?
It was, do you believe that she wants to kill herself because you
Okay.
can't see her?
Okay, I don't believe she wants to kill herself, but I do believe that based on comments that she's made to numerous people in numerous situations, I believe that she is in extreme distress from being cut off from me, and I believe that she's expressed that, and we'll get into that later. But I do not believe she wants to kill herself. I do believe she wants somebody to show that they care about her feelings and the pain that she's been subjected to.
You stated that it's Musically, which is now TikTok. It
I
just
think
changed
so.
names.
I think
Is that- Okay. So when is the last time that you reached out to Dilara on that social media site?
I don't remember, but I'm pretty sure that her dad blocked her from saying anything of mine. And, it's like throwing rocks on the playground. I mean, you get some one-shot deal once, or sending, he's gonna stop it. So, he intercepted you. He cut off that lifeline
When
that
was
she is.
that?
It was in
When was
September of this past year. I don't know that she ever. I don't know if she ever saw anything that I posted on Musically. I don't, because I don't know if it was him or her.
Meant to be messages to her.
I did. I will continue to reach out and post messages that I hope she will come across someday to know that I have been all this time. I don't care, and if it takes the next 8 years, there will be a paper trail of me leaving breadcrumbs and letting her know that I care about her, even if nobody else does, and I'm still fighting for her rights and to get her needs met, even regardless of how many people put up roadblocks in between us. But I don't know that she has seen anything of mine. except I do know that she saw Sidewalk Chop. But as far as anything on social media, I don't think she has seen anything of mine on social media other than what I have shown her on supervised visits, which were Rabbits and her friends.
The sidewalk chalk that you're referencing is what you talked about during Ms. Carlton's questioning of you. It was at a park in their neighborhood.
I've chalked all over town, and other people have too.
Since this order was entered in August of 2018, have you chalked at their playground in their neighborhood?
Yes, several times. Well, not several, a few
When's the
times.
most recent time?
A couple months ago, maybe. I don't know. I've been out there and talked to parents in person. Maybe it was January. Maybe it was the end of January. Might have been January 31st. Was the last time.
Okay, so a little over a month ago. And
I
how do
think
you
I
know
think I
that
have
she
done
saw
it this
that?
year.
How do you know that she saw that sidewalk chalk?
I don't. The only sidewalk chalk that I know she has seen, I know she has seen it because of what her father's testimony, because he witnessed her seeing it or commenting on it. And I'll be asking him about that.
Do you think it would be embarrassing for Dilara if her friends saw something that said #free Dilara? Do you think that would be embarrassing for her?
No, I think she's proud of it based on what I've heard. I think if it was embarrassing, she would not have called attention to it and said, "Look, my mom wrote this," which is what her father said. She was her response when she saw it. She was, based on what her father's testimony in criminal court, she was very pleased. So I'm glad he made that known. Otherwise, I wouldn't have known. I don't think she would have called attention to it herself and shouted out to the playground if she was embarrassed. I think she would have maybe tried to erase it or stood in front of it or...
If the court allowed you to have visits, would you talk about the court proceedings with Dilara?
No.
Your previous testimony is that you weren't going to give the court discretion over your conversation topics. How can the court feel confident that you will not talk about this case with Dilara?
Well, and I think there needs to be more specific directions given as to what is talking about court, because and I think I know Christine Carlton was there. I know Guardian ad litem heard this in case they say it's hearsay. He was there, and Jessica Addington was at Youth Villages. And when something came up about court, and I said, because she had said Dilara was talking about court, and I'm like, well, where is she getting the idea of talking about court? I'm not discussing court with her. And Jessica Addington said, all of this is court to her. So Dilara, that was my position. I mean, she's affected every day by court stuff, whether she talks about it or not. So Jessica Addington, which she and he and we all heard Jessica Addington say, based on her 2 months of therapeutic visitation with Dilara, that all of the strangers coming into her life, asking her questions, there's been like 20 or 25 different strangers coming into her life, between counselors, between DCS personnel, between visitation supervisors, between the special ed people at school and evaluators. I added them up, and there was over 20 strangers coming into her life. And Jessica Addington said that is court to her. So if Dilara was on a visit with me and she asked me about Jessica Addington, or when her whole life is, she's like frozen in a block of ice, floating in a sea of court stuff. So just seeing me might trigger thoughts of court. So basically, the restrictions on me are so broad that, which I believe they're unconstitutionally broad and vague. I'm sure that if I said, oh, your hair looks nice, somebody will connect that to court in the time where the father said I should not have told her she needed to wash her hair. So everything can be connected to court in one way or the other if you're looking to do that. So I'm sure that until the Court of Appeals overturns these things and or we get a different judge, or somebody acknowledges that this is just a complete abuse of the legal system, and I just feel like anything I say, because I'm her mom, okay, so she sees me, oh, you're cut off, if she just seeing me will trigger thoughts of, oh, I miss my mom. Seeing her being at school, seeing somebody else's mom, that'll trigger thoughts about her mom in court. She cannot get away from court because her whole life is about court. So you can put a gag on me, you can keep me from seeing her, but she is still being affected by the fathers and DCSs and guardian ad litems, keeping her in court. It's all these restrictions on her are. She's aware of them. She's aware of what she can say and what she can't say. She's anxious about it. So.
An objection, lack of personal knowledge of what the
I'll
client is
sustain.
anxious about.
I'll sustain.
Well, I know what she said.
I'll sustain.
You're done.
Are you done? Okay, let's take a 5-minute. Okay. Stretch break. Oh, it is lunchtime. No wonder I'm getting. Let's not take a 5-minute stretch break. Let's take a lunch break.
Coming back when?
All right, let's come on back by 12:30.
12:30?
Yeah, let's take a lunch break. 12:30. Y'all can leave your stuff in here and we'll lock it up.